My name is Julie Sook. I'm a professor of law at Fordham Law School in New York City, and I write about gender and constitutions in the United States and around the world. I wrote a book about the revival of the Equal Rights Amendment called We the Women, the Unstoppable Mothers of the Equal Rights Amendment, which was published in 2020. And I see some of you are holding them up. If you have the book and would like me to send you a signed book plate, just send me an email. When I stop talking, I'll write my email into the chat. And my next book just came out in April. It's called After Misogyny, How the Law Fails Women and What to Do About It. And so if you want to buy it directly from the UC Press website, you could type in save 30 and get a 30% discount. But I mentioned these books because almost everything that we'll talk about today, I go into greater length in those books. And so I'm thrilled to be here. I'll be at the convention in Seneca Falls this summer, and I look forward to meeting some of you in person and look forward to the conversation.
Beautiful. And we will, of course, be drawing from We the Women throughout the conversation. So this will be it'll be a privilege to have Professor Sook specifically to sort of speak on a lot of what was covered in that book. But so just to allow us to get started and sort of on a broader scale, what kind of social and political issues have we seen animate women's protest for the ERA, and how has that differed in terms of the responses and the efforts seen in the United States and movements sort of outside of the US, and how that push towards specifically mobilizing the people and mobilizing towards some sort of solution has differed, and kind of why?
Should I start?
Absolutely.
Okay. So I know I'm jumping in on the third session here. And of course, the Seneca Falls event this summer is the 100th anniversary of the introduction of the ERA. So it makes sense in some ways to start in 1923, where it was the right for women's suffrage that really animated the movement for the ERA, because we all knew from the beginning that the vote was not going to be enough. There was legal patriarchy. Women were excluded from many other legal rights other than simply the right to vote. So that's what the ERA was about from the start. But in 1970, when it finally gets adopted by both houses of Congress and starts the process that we're now in, and this is the ERA that's now like making the rounds, the ERA of the 1970s, of course, this is after women have the right to vote and after at least some aspects of legal patriarchy have been dismantled, but there are movements that say we still need an amendment to the US Constitution. And it's important to point to the women's strike for equality in 1970. Three major issues: equal employment, abortion on demand, and 24-hour childcare centers. So to put it simply, it was really about all of the legal disadvantages and social and economic disadvantages resulting from those legal disadvantages that women faced because of their reproductive role. And because of the reproductive role, they're excluded from certain jobs, paid less in certain jobs. Because of the reproductive role, they're forced to be mothers when they're not ready to be or don't want to be. And because of even when they choose to be mothers, the lack of childcare makes it impossible for them to be anything more. And so these were, from the beginning, really important issues. And you see the through line from 1923 to 1970. And you see that through line to today, because we have attacks on reproductive rights, complete lack of support in the United States for childcare and motherhood, and high rates of maternal mortality. And these were the issues and are the issues that have animated the protest movements.
Yeah, absolutely.
Yeah, I mean, I think it's basically a mirror, right? What we've seen in Latin America is that legal difference creates social differences. And so after the Second World War in Latin America, there was a huge movement of equality for women specifically, because they were seeing issues on maternal health, on prenatal leave, on labor rights, on sexual and reproductive rights, on pensions, because of the role of care that women usually take on with maternity, but also taking care of grandmothers or taking care of sick relatives, and that obviously affects their pensions. So we start seeing all of these social issues that come after legal issues, gender parity and others. So what started as a protest against gender-based violence, against high maternal rate mortality after like prenatal leave and other social issues, became the seed of constitutional change in Latin America. And we start seeing equal rights amendments or clause. We start seeing health in constitutions. We start seeing economical, social, and cultural rights recognized in constitutions, because it's not just upraising about equality. There's so many other rights that can be and that make a huge difference when they are enacted in your constitutions. So that started happening after the 40s in Latin America. And that also creates a shield for women and for sexual minorities, for African American people, for Afro descendants in Latin America as well, for immigrants to actually have kind of like a shield, a social and legal protection in the constitutions. So all of those protests between the 40s and the 70s, and then after, when we had dictatorships in Latin America between the 70s and the 80s, the protest to end dictatorships was what created this huge social tissue that is what you see on social media right now, where we have 1 million, 2 million people protesting on the streets. So I mean, I feel like it's a mirror, because all of those issues that Julie very cleverly pointed out are the same ones that we saw in Latin America. We just saw them a little bit before, maybe because of the lack of growth that enable those struggles to be present before in Latin America.
Absolutely. Thank you so much. And I know we discussed sort of what issues have driven women-led protests, both in the United States and also abroad and all over the world. But how do you both see the change in movements and the change in sort of pushback against a lot of the injustices specifically related to gender and reproductive injustice and limitations differing in governments that are authoritarian or characterized as such, and oppositions that we see in the United States? And how do you think those legal bodies, legal systems, and governing systems sort of inform the way people act and people push for change?
Should I go or should you go?
Absolutely. You can jump in.
Yeah, Belén, you could start and I'll go next.
Yeah, I believe that one of the most important things for me in different legal systems is the acknowledgement of international human rights law, that it's present in both Europe. It's not just a global South issue, which is what I'm trying to say. Like it's a worldwide phenomenon. Acknowledging human rights standards and human rights in treaties and human rights bodies being able to have judicial decisions against states for violating human rights in the country's populations are a huge shield, obviously, for populations in those countries. And that's something that the US lacks, right? But also the ability to actually have cases not on the Supreme Court to protect what we have in Latin America, to protect rights, what we have in Latin America in amparos, recursos de protección, different like judicial tools that help to protect rights when they are violated without having to go specifically to the Supreme Court or to wait 5 or 6 or 10 years to get like a resolution on a topic, right? So there's obviously there's differences in our legal systems, but there's more things that we have in common than those that that are different. Like I do believe that, of course, adding an amendment like the ERA could help tremendously to women's rights and sexual and reproductive rights and LGBTI rights, right? But of course, to be able to create that, there needs to be a change in the movements like we know them in the US. I do believe that the movement needs to be bigger, needs to be more articulated, needs to be bolder. needs to understand that the social changes that the US need are not just a women's issue, are not just young people issue or young people crying or being snowflakes about some social topics, like sometimes I feel like this is portrayed. There are huge topics for elderly people, for immigrants, for refugees, for Afro-descendants, for like indigenous people, for people with disabilities that are protected because of our strong constitutional rights. And that's something that the US lacks. And again, it's the recognition of economical, social, and cultural rights. It's democracy cannot just be upheld by voting. That is not the only right, or by freedom of expression, right? Like after the Equal Right Amendment is passed, I hope you pass a non-discrimination clause in the Constitution, which is something that we also usually have in Latin America, like clauses that protect like substantive equality, not just formal equality. But again, yeah, I'll let Julie, because that's her topic.
Well, as Belén's comments suggest, we could spend a whole course for a whole year talking about a lot of the differences between legal systems. I'm just going to focus on one because we are in an ERA convention, specifically about the approach to constitutionalizing some vision of feminism or gender equality. And I think that the most influential figure in the United States with regard to that as a legal project, and there's like social and economic issues, but as a legal project, the idea that the Constitution should guarantee equality, gender equality in some way. Ruth Bader Ginsburg was a fierce advocate for the ERA in the 70s, and she also led the litigation that brought the idea of sex equality into US constitutional jurisprudence through the Supreme Court. And of course, as Belén points out, going through the Supreme Court is a very limited way of realizing a vision of rights. If you think about who's sitting on the court today, what they will do if you tell them, interpret the Equal Rights Amendment, it's not a really inspiring tale. So it's really important to note that in the United States, from the beginning, when we had that women's strike and all those women in Congress advocating for the ERA, they did not think that the ERA was a project for courts. Or courts alone. They didn't think that the Supreme Court was going to be at the forefront of feminism, and they were probably right about that. They thought that what the ERA would do was raise awareness at all levels of government and amongst we the people about the importance of implementing gender equality through legislation and having clear constitutional lines of authority and obligation to do those things, and to do those things in the absence of the United States having a good relationship to international human rights law that might otherwise obligate the state to do things for gender equality. And so this is really important that we imagine the ERA as addressing not just courts and lawyers and the Supreme Court justices and judges, but everybody and every legislator in particular. And it's really important that Ginsburg's idea, RBG's idea of gender emancipation, that women should not be confined by their traditional role as wife or mother, should not be stereotyped on the basis of gender, and that men too could be liberated if they weren't expected to be masculine breadwinners. And so this is a story of gender emancipation. And she gets it from Sweden in the 1960s, where they're having this debate about how men and women both should be emancipated from all of the oppressive expectations of patriarchy. What's fascinating in Sweden is that they don't focus on a gender equality amendment. They don't focus on non-discrimination, which we think of as the pillars of gender emancipation. In Sweden, the major constitutional reform that they get in the 1960s and 70s is they reform the legislature, right? Imagine a dysfunctional bicameral legislature. Not that hard to imagine because we have one in Congress, right? And in Sweden, they say, let's reform the electoral system so that it actually proportionally represents the country. And then they reform the legislature. It becomes a unicameral legislature, and they're actually able to like fund things and pass legislation. This is where you get those childcare centers, which we were talking about in the 1970s, Women's Strike for Equality. They build child care centers. They fund parental leave, not just for women, but for men. because if men aren't taking parental leave, who's going to get stuck with childcare by default, right? So this idea that you're, instead of focusing on courts, focus on like building a political process that fairly represents everyone and can actually fund the infrastructure of gender equality. Because simply declaring gender equality by law is very different from having an infrastructure that makes it real. And that's something that I think the ERA would be a step in achieving. It wouldn't be the whole machine. Once you get the ERA, you would then have to get your political institutions to pursue the legislation and build that infrastructure so that we could actually have gender emancipation.
Absolutely. Thank you so much for that. Yeah, I think that really heavily encompasses, and we're going to sort of move into the legal framework, especially of things like the Equal Rights Amendment and how that will really impact gender inequality in this country, and sort of putting ourselves in the mindset of having the ERA and how that will affect laws in this country, because I think that the Columbia ERA project and other institutions and efforts are really paving that conversation of the constitutional, framework and the legal framework of the ERA. But to what extent do international legal frameworks ensure accountability for government negligence of gender justice, such as in the United States? And how does the United States, if at all, of course, compare to that?
Well, I could just pick up where Belén was earlier. So when you say international legal frameworks, I think you might be talking about two different things. One is the body of international law, so international human rights instruments and treaties, dating back to the UN Charter on the Universal Declaration of Human Rights, and also CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. These are really important frameworks that basically say, make gender equality real, put gender equality in the Constitution, do all kinds of things that are really important to gender equality. And of course, as Belén mentioned, the United States does not automatically regard international law and international human rights law as part of US law. There are many other countries that regard international law as part of their law, and that's in their constitutions. We've really struggled with that in the United States. So that's one issue. I think when you say international legal frameworks, you might also just be talking about models of equality in domestic law in other countries. That's comparative constitutional law. And it is a fact that after World War II, many countries heeded the treaty recommendation or obligation to implement gender equality into domestic constitutions. So now if you have a constitution written anytime after 1945, it's really rare that you would have a constitution that does not have an ERA. It's like now it's considered like a basic staple, like freedom of speech, freedom of association, right? All the things that you think of as basic to a free democratic society and political system. Gender equality is considered a staple in most other constitutions around the world. And it's just an anomalous fact in the United States that we don't have it, in part because we have the oldest constitution in the world. And I think someone mentioned in the chat, a constitution that's incredibly difficult to amend by comparison to other constitutions in the world. And so the story of the ERA that I tell in We the Women is really about how there's something that's so basic, that so many people support, yet we have a structure, including an amendment rule, the structure of Congress, the structure of state legislatures, and how they actually work in practice, and how they've evolved since the founding, when the country was much smaller, that makes it impossible to put something that's incredibly basic to the functioning of a modern democracy into our Constitution. And so I think it is really important that not only do these other constitutions have a basic guarantee equality between women and men that emerged after World War II, then they've also struggled with the question that everybody's waiting for the Supreme Court to decide, which is, if you have a basic equality clause in the Constitution, does that mean that we can make distinctions between people based on their historic disadvantages that they may have faced, whether it's because of race or because of gender? The Supreme Court's about to decide the affirmative action case. They're about to say that you can't even distinguish on the basis of race for the purposes of helping a disadvantaged group. That's something that's very distinctive to our constitutional interpretation of equality. Lower courts in the United States have said the same thing about measures to help women. So gender quotas, to diversify corporate boards in California have been struck down by at least one state court in California, invoking a vision of equality that's like colorblind, gender blind. Many other constitutions overcame this difficulty in the 1990s and the early aughts by amending their constitutions to make it very clear that you could have positive measures to overcome the underrepresentation of women. They're framed as the law shall promote equal access by women and men to positions of political and social responsibility. That's the language in the French Constitution. The German Constitution, in an amendment in 1994, includes a clause today that says the law shall promote actual equality between women and men and eradicate disadvantages that now exist. So to the extent that there were courts doing what our court is about to do, probably this week or next week, which is to enforce a very formal colorblind, genderblind idea of equality, there were amendment movements that responded to that to make it clear that equality, substantive equality, would mean the ability to distinguish between those groups for the purposes of overcoming underrepresentation and disadvantage. And that's something, it's not necessarily baked into the ERA, but I think that if you read the history of the ERA carefully, it is something that the ERA can also achieve, although people would have to work to make sure that that meaning, that substantive equality meaning, is the one that is embraced by courts and other institutions.
Yeah, I would only add that there's also American body treaties, like inter-American body treaties. It's not even just the universal system. It's not only the UN treaties and the Universal Declaration on Human Rights. We also have the American Convention on Human Rights. We also have Belén do Pará, which is the convention specifically to eradicate violence against women. So there's a whole legal framework of international human rights law that it's at disposal of women and usually discriminated groups that the US doesn't really acknowledge much. And also that I agree completely with Julie that the ERA could be one stepping stone to start creating a constitutional interpretation in favor of a lot of things that are not necessarily on the actual text of the ERA, because that's what happens with live constitutions all the time. We interpret them with other clauses in mind, like dignity clauses, like access clauses, like well-being, like the pursuit of happiness in your constitution could be one stepping stone in, like, if you add another clauses of your constitution and start interpreting them with human rights standards in mind. There's a lot of new and valuable interpretations that could come up. Yeah.
Absolutely. And I also want to draw the curtain back a little bit on gender justice movements. I know we touched on this in the first sort of prompt a bit, but I was wondering sort of how you both see how international gender justice movements have influenced or impacted similar efforts in the United States. I know specifically we can sort of think about the response to Dobbs versus Jackson and the fall of Roe versus Wade, and what we can sort of gain by studying these movements that sort of happen internationally.
Okay. Yeah, the fall of Roe versus Wade was a shock. I know it wasn't a shock in terms of the Supreme Court justices that were in court right now, but you guys were the example that we were all following. Roe versus Wade was such an early judicial decision, at least in Americas, right? We had some other early decisions in Germany, we had some in Spain related to abortion, but really Roe versus Wade was one of the key components of all the sexual and reproductive rights movement in Latin America in terms of what we could potentially achieve, right? So of course, in that sense, it was a complete shock when it fell. But in terms of women's movements and feminist movements achieving legal change or constitutional change even in Latin America, is something that I usually debate with feminists in the US, and it's the lack of actual movements in the US, like big gatherings of people with a common agenda that are willing to protest and how that differs maybe with the protest movements that were in the 60s in the US or in the 50s in the US, and the civil rights movements and the suffragettes, and how that got lost at some point in the US and why, and how can we make that comeback from social tissue and from grassroots movements and from young people. Because what we saw in Latin America in different stages, because Latin American countries are a different world. Like it's very hard to talk about Latin America as a one scenario where we can just assimilate experiences. But what did happen in Latin America as basically a whole was that we had huge dictatorships, right, on the 70s and the 80s. And so when we achieved democracy again, protesting was a big part of a whole generation of people trying to gain back democracy. And then what happened is that people like me, we were born in democracy. We were the first generation born in democracy back in our countries. I was born in the 90s and we got democracy back on 89. So what you saw was a generation that wasn't afraid of being shut down by the military dictatorships. You saw a generation that was actually seeing their parents afraid of change because of the experiences that they've had. And you saw a generation that really hadn't had that experience, that started taking on the streets for free education, for free healthcare, for changes in the political systems that were created in those dictatorships to help maintain power by some elites, right? And so those grassroots movements were not just fighting for abortion. We were fighting for a whole new vision of democracy. And that made us as huge as we were. You need to put things in perspective. In Chile, there were 2 million people protesting in 2019, and we're a country of 17 million people. That's 10% of the population. That's 30 million people protesting one day in the US. That's kind of like what it would be. Like, can you imagine how that would look? 30 million people on the streets claiming dignity and healthcare and free education and fair pensions and the right to care and abortion and gender equality. That's the kind of thing that happened in Latin America. And of course, it wasn't free. There were a lot of repression and political repression, and people were incarcerated. Some people died. Some people lost their eyesight. Like, there's consequences to that kind of upheaval, social upheaval. But I do believe that in the US, there's not that social tissue. And maybe it's because you guys don't have free healthcare and you guys don't have free education. And so people fend off for themselves. And so there's not a sense of community, or that sense of community, it's basically in very specific US experiences. I do believe like the African American community has a big sense of community. I believe that Latin descendants have a big, very sense of community, and other like Asian Pacific, but it's not a US thing. It almost seems that it's by design to be thought of as a selfish kind of like, yeah, like a selfish community, right? So I believe that that is one of the differences, but I don't believe that that cannot be changed. Like, I do believe that there's an empathetic, huge part of the population that would be willing to make those changes and would be willing to just stand up and protest for people, for others, right? So I guess I want to hear from US-based and born people about how would you try to do that, I guess.
So I'll say, I think the question you asked, Emma, was how do international gender justice movements influence or impact similar efforts in the United States? And I think there is a real problem of ignorance and lack of imagination in the United States. And just starting with, if you think about what you learned in civics from elementary school through high school, you probably learned a lot about the US Constitution and the 3 branches of government and the founding fathers. And even when you studied global history, I have kids in high school and middle school, even when you studied global history and studied about European history, World War I and World War II, I bet you did not learn about the constitutions of those countries. And I think this is a real flaw in the way we're educated, where we learn a lot about the US Constitution in the mode of religious veneration, and we don't see that there are alternatives to how a constitution and political institutions can be structured. We teach US constitutional law. Comparative law is barely taught in law schools unless people select into it. So I think even amongst experts and elites, there's a real lack of knowledge and a real lack, and with that lack of knowledge comes a lack of imagination. And I've encountered, because my new book, After Misogyny, is largely about constitutions outside the United States. But I also find that across the board, and I see it in the comments in this chat as well, I think there's certainly a great deal of skepticism about the importability and transplantability of outside of the United States constitutional ideas. Like, these are science fiction pipe dream ideas that have no realistic chance of success in the US. So why should we bother knowing too much about them or even trying? And it is true that the US is incredibly different. It's a much larger country. It's gotten much more polarized, so that even things that worked 50 years ago probably can't work even on our own soil today. So there are all these differences we have to keep in mind. We should not assume that things are transplantable, but I think sometimes the assumption of non-transplantability leads to a cynicism that leads to lack of imagination, and lack of imagination just kind of perpetuates the ignorance. And I think we have to start somewhere. So what I'm trying to do in my research and in my work and in talking to groups like this is to get people to a place where they can at least imagine and think that something else is desirable. Think that the thing that you've learned to venerate since you were a child is actually dysfunctional. And what would it mean then if you think that it's dysfunctional and you want to find ways of changing it? And you have to be honest with the barriers. You know, Article 5 is very hard, but I do think that engaging other countries and seeing how there are different models is a really important first step. And that first step means also encountering some things that you might feel uncomfortable with. So one thing that you'll see if you look at reproductive justice movements around the world is that they didn't reason from privacy like Roe. Roe is not a well-reasoned decision, even though it became a symbol for something really important to women's rights. 9 guys on the court said this was a matter of privacy, whereas in many other countries around the world, they reasoned more in terms of not the ability to control your own body because it's private, but the ability to control your own destiny. How does becoming a mother affect that? And not just controlling your own destiny as an individual, but the fact that society expects countries to be reproduced and raised and educated. They disproportionately rely on one part of the population to do all that reproductive work with very little valuing of that reproductive work or compensation of that reproductive work. And I think those types of insights have been really important. Other constitutions, they don't just guarantee gender equality. Many constitutions after World War II also said motherhood deserves the special protection of the state. That sounds like a huge gender stereotype that Ruth Bader Ginsburg would disapprove of, but it's really amazing what these clauses did to ensure that women would get paid maternity leave and accommodations on the job if they were pregnant, and just full recognition of the sacrifice that it takes to raise a nation by staying pregnant, giving birth, and raising children. It doesn't mean every woman has to do it, but it means you need political and legal structures that recognize the value that's produced on certain people's backs. And I think that's really important. And what's really important about that is that it might mean that the way that you reason about abortion is about supporting motherhood as much as it is about the right to do whatever you want with your body. And that might be uncomfortable for those of us who are used to thinking about it a different way. But I think it's important because many of the liberal ideas rooted in privacy and individualism are not really advancing the cause of women of all different colors and classes in the way that perhaps we had hoped that an idea of equality would.
Absolutely. And this is sort of a follow-up to what we've been discussing, and a personal question of mine, but I do believe that it's relevant. We've seen, especially in Latin America, gender justice movements and efforts push for policy that decriminalizes abortion more so than legalizing it. I mean, we can think of Argentina in 2020 specifically, which decriminalized abortion. Whereas I think in the United States, oftentimes we see prioritization, and sort of the first assumption that we jump to is legalizing different provisions with various factions of our political system. I was wondering if both of you would be able to draw the distinction between decriminalization and legalization by vein of abortion, and what that would mean specifically in the US, and why I think oftentimes we jump specifically to legalization as opposed to decriminalizing these things.
Yeah. There's been plenty of movement in the courts in Latin America in the past 7 years. Chile decriminalized abortion in 2017, then Argentina in 2020 legalized some legal clauses on abortion, and then just recently Mexico and Colombia, they both legalized abortion. Colombia surprisingly up until 24 weeks. So there's been a lot of movement in Latin America in that subject specifically lately. So I would say that there's two main differences, I would say. The first one has to do with the consequences that women face when they have an abortion. When abortion is criminalized, that means that a woman that has a voluntary interruption of pregnancy has to go to jail if she passes through the judicial system, right? So we have in Latin America, actually, countries that completely ban abortion. So that means that women that have had an abortion, if they face prosecution, they might end up in jail. That's the case of El Salvador, for example. So when we decriminalize abortion, we take that criminal type, we would say, or that crime from the criminal code, so that it's no longer a crime. That's decriminalizing, basically. And the focus of Latin America in decriminalizing first is that we are facing a lot of women prosecution. We're seeing women die on jails because of an abortion. That's happening right now in El Salvador. There's women that are facing 10 or 20-year jail sentences for having an abortion. In El Salvador specifically, sometimes it's even an spontaneous abortion. So that's even more perverse, right? So there's, of course, a focus on, first, not getting more people in jail, and second, trying to get the women that are in jail right now to be free. So there's this focus in Latin America right now that it's not something that the US usually has had to deal with, but we're starting to see it in some states, right? In terms of legalization, that means that it's actually legal to have an abortion. And that means in Latin America, in constitutions where we have health clause, where we have equality clause, where we have health provisions or healthcare, that means that the state actually has to guarantee an abortion. So it means that health professionals, public health provisions are in place to guarantee an abortion with some set of standards depending on the country to actually have that procedure, like that medical procedure. So we see the difference between like abortion as a crime versus abortion as a procedure, as a health procedure. And that's like the main difference. So the focus on decriminalization first was basically that we need to take women and girls sometimes out of jail. And then in some countries with strong health clause, with strong other equality, non-discrimination, dignity clause, we try to move forward with legalization to ensure that after it's decriminalized, every woman can actually get the procedure, which is something that you see in the US as well, right? Usually high class women are the ones that can get the procedure done because it's expensive, because they have to travel, because Some doctors don't want to perform an abortion in certain states, so they have to move. So the legalization deals with all of those issues. But yeah, I don't know if Julie wants to.
Yeah, I think so as a comparative lawyer, the ideas of decriminalization and legalization probably mean different things in different legal contexts, because the way that Belén is talking about legalization, by her definition, even under Roe, abortion was not legal in the United States because there was no access. The law did not guarantee access, it just decriminalized. It was a total negative rights model, meaning that the state could not interfere by criminalizing doctors or women who were having or performing abortions. But shortly after Roe, we got the Hyde Amendment, which said that public funds could be withheld or had to be withheld from not just like voluntary abortions, but for abortions that were necessary to protect a woman's health, right? So if the Hyde Amendment, and then we get Supreme Court decisions saying the Hyde Amendment is totally compatible with Roe versus Wade. So I think that it's important to note that decriminalization, and it's also important to note that in the United States right now, we're getting a lot of abortion bans in many states that don't criminalize the woman getting the abortion, they criminalize the doctors. But it creates a situation of total non-access, even in situations where abortion should be technically legal, which is to say a lot of states are passing these abortion bans that say abortion is legal if the pregnancy poses a threat, an emergency threat to the woman's life. But the reality on the ground is that even if it's legal to get an abortion, when the pregnancy is a threat to a woman's life, if the doctor will be subject to criminal sanctions in a situation where there's a disagreement about how sick the woman was she close to death or not so close to death? Was it just a threat to health or a threat to life? These are questions on which there could be disagreement and by minute, second by second changes to the health status of the pregnant person. So I think the reality is that even if you decriminalize the woman, if you criminalize, or even that threat without criminal sanctions, if you just threaten to take away the license of a doctor who performs an abortion, the nature of the situation of pregnancy and threats to pregnant people's health and lives makes it kind of unworkable anytime you have these, what's essentially, I think we should be thinking of it on a continuum, not just categories of legalization and criminalization or decriminalization. I think those are unimportant. We have civil sanctions as well. I think what's really important is just what is the effect of the law and the law's regulation, whether it's through criminal sanctions or through other means, what is the effect on actual access to abortion, and what is the effect on the woman's ability to live and shape her own life? So I guess I would encourage people to think in those terms, in terms of abortion access and the effects of any legal regulation on actual access on the ground, rather than through these legal categories that have different meanings in different countries and different legal contexts.
Absolutely. Wow. And with the time that we have left, I just want us to hit on one final point. I know we've sort of dispersed this all over the conversation and talked a bit about it, but how do gender equality provisions proposed in the Equal Rights Amendment in the US compared to gender equality provisions in other constitutions?
Well, I think it remains to be seen. The Equal Rights Amendment was very sparsely drafted. It was very abstractly drafted. All it says is equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex, right? So very few words, very simple. But I think it doesn't say what equality means. It doesn't say what rights are included. It just doesn't define sex, which could and probably should include gender identity, sexual orientation, pregnancy, but there'll be disagreements about what's included, right? So I would say that because other constitutions have been more amenable to amendment, some of the ambiguities that I'm raising are not in other constitutions. They had equality between women and men in the 1940s. Then in the 1990s, they got these amendments, and those amendments grew out of fights about equal representation, gender parity rules in many countries. So if the Constitution now says the law shall promote equal access by women and men to positions of professional and social responsibility, then that's very clear. So I think that the ability to amend has made it much easier to have more robust interpretations in other countries, but that doesn't mean it's lost here. It just means we have to work harder and do more. So if the language that I just read you, hand that to the conservative justice majority on the Supreme Court today, and my guess is that their interpretation of it will be very different from an international human rights, substantive equality, reproductive rights protecting vision of gender equality. So if you want to get the full substantive equality, international human rights, reproductive justice model of gender equality into the ERA, you have to create a record of a legislative history. This is what we intended when we ratified. This is what Congress intended in the 1970s. And that's part of the work that I'm trying to do in writing a book like We the Women. What I'm trying to do is dig up the legislative history from the 1970s to show that there was a connection to the women's strike that said abortion on demand, 24-hour childcare centers, right? People don't know that. People don't know that these concerns about reproductive freedom were part of the original vision of gender equality, even back to the 1920s. But we have to make that history clear, because if we don't make that history clear, and if we don't make the modern meanings count in the way that the ERA is traveling through Congress and perhaps through additional state legislatures, through the archivist's office, wherever you go with the ERA, those meanings have to be there. Because if they're not there, the judges who are looking at it will treat them as invisible and non-existent.
Yeah, no, I agree completely. And if we see the history of equality clauses in Latin America, the first ones were really abstract, very small even. It was just equality between men and women. That was like the generic clause. Like, this constitution guarantees equality between men and women. That was like the actual text of many of them. But then with reforms, usually in the 90s, because of political fights from women to actually become part of political life, either by being part of the legislative bodies or to just hold positions of power, those articles begin to grow more robust. And that, with judicial interpretation from progressive courts and with the support of international human rights bodies, systems, and treaties, create what we see now, that it's like the robust clauses that we have in countries like Colombia, that we have in countries like Uruguay, that we have in countries like Argentina, that are not just formal text, but are also the interpretation of said text with modern day standards. So I do believe that even a small, very abstract text could become potentially, with the right interpretation, a very modern and progressive provision that could encompass sexual and reproductive health, that could encompass dignity and economic and social and cultural rights. I have no doubt that that could be done. Specifically, if you have also the history that Julie is telling us about how abortion on demand was part of it, about how like healthcare, like childcare was part of the demands originally. Like I do believe that the clause that you have could mean a very progressive view on equality and non-discrimination.
Beautiful. And we have a question in the chat with the limited time that we have left, of course, that's related to this. Belén, we have Kate's wondering sort of what your hopes and aspirations are for the Chilean Constitution and what your favorite part of the initial draft was. So maybe delve a little bit deeper into that one.
Okay. Why? Okay. Okay. My hopes and aspirations for the Chilean Constitution. So for people that don't know, Chile went through a social upheaval in 2019 that ended up on a very specific and modern body drafting a new constitution. And when I say a new constitution, I'm talking about a whole new text, not just provisions of a constitution, just a whole new constitution, right? And that was very exciting. It meant that Chile could become a more modern and progressive country with more modern economical and social, cultural and rights clauses, with more non-discrimination clauses, and with just like a a system that could enshrine equality and dignity. So it is very exciting. The draft itself ended on 2022, and then people voted if they wanted to approve that new constitution or reject it and continue with the one that we had since the 1980s that was drafted in our military dictatorship, and people rejected the new text. So that meant that for now, we are stuck with our old constitution, but there's a new effort for a new drafting coming from experts that are more conservative than the first drafting body to create a new constitution, because people still believe that our current constitution is an issue. So we need to do something about it. And this is the new drafting body. So that being said, what are my hopes and aspirations for this new body? I hope that they take into consideration the best parts of the first draft, which I believe were like the acknowledgement of international human rights bodies as a constitutional part of our system, like with the same degree of importance and hierarchy than our constitution. I do hope that they take into some consideration gender parity as one of the main pillars of our democracy. I do hope that they take into consideration the inclusion of indigenous people in our political bodies, either in the judicial system or in the legislative system, even if we don't have an indigenous court system like the one that was proposed in the first draft. And I do hope that this can actually end with a cycle of violence and protest that started in 2019, that it's not necessarily gonna end with a text, but we need to kind of become a community again. And this process has really broken some of that social tissue and some of that community, and families are fighting about this. And so I do hope that this ends with a text that we can all call our own, which is something that constitutions need to be. Constitutions need to be something that you feel like your own to actually work, because they are what we believe we need to be as a country, right? They're the roadmap of what we want. So I do hope that that happens. And my favorite provision of the draft, I would say, was the first chapter that was about like what we hope to become and what we hope to be as a country. And it talked about dignity, and it talked about equality, it talked about affirmative action, it talked about the importance of vulnerable groups. So that was my favorite part, and I'm really sad that it didn't actually happen. Yeah.
Beautiful. There you have it. I think that is obviously we're very limited in time. I think that's a wonderful place for us to stop. This was such a fruitful discussion. Thank you so much, Belén and Professor Suk, for joining us today to discuss this topic. Obviously, this is just one part, one installment of our recurring Reimagining Gender Justice series. We have a new installment coming soon. So if this is something that sparks your interest and is something that you want to continue interacting with and engaging with, stay tuned with us for this series. I hope everyone sort of gained something from having this conversation. I think oftentimes we have a very limited perspective and limited view of how the ERA and gender equality provisions in our legal system in the United States can sort of make way, but don't oftentimes look at the global perspective. So this was really, really wonderful. Thank you all so much, and have a great rest of your day. And thank you so much, Professor Suk and Belén. We really appreciate it.